After months of negotiating, I finally got the defense to offer $1 million to settle your case. In my opinion, this is a fantastic result. When I tell you the answer, when I tell you what they've offered, you turn around and say, I've changed my mind. I want $10 million in order to settle my case. What happens next? You want to know the answer? Come join me for a walk around the lake as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, a number of things are going on here. Number one, you and I have had a conversation about the value of your injuries months before I ever started negotiating with the defense attorney. Now, I gave you my full analysis. I gave you my opinions about what I felt was the full and fair value of your particular injuries. At some point during our conversation, you actually agreed. And I asked you the question. I said, listen, if I am able to get $1 million or more, my recommendation is to settle your case, because that would represent a fantastic result. You agreed after spending over an hour on the phone with me, listening to all the pros, all the cons, all the risks associated with continuing your case and continuing all the way through and including trial. So now, based upon that specific conversation and based upon your consent, your explicit consent to me that if I am able to get $1 million or more, then I have your consent to go ahead and settle your case. So now I enter into good faith negotiations with the defense attorney. And over the course of months, I am finally able to get the defense attorney to offer what I believe is full and fair value for your injuries. Now, in the interim, you've been talking to somebody. Somebody's whispering in your ear, and somebody has told you that your injuries are clearly worth more than $1 million. But you failed to tell me about it. You failed to tell me you had a change of heart. You failed to let me know that you no longer had an interest in trying to settle your case for $1 million. Now, I'm at a significant disadvantage because I've been negotiating with the defense attorney with the clear belief that this is the goal, this is the clear number that we need in order to settle your case. So now, after hard-fought negotiations where the defense was refusing to offer any substantial money at the very beginning, now over a period of months, I was able to convince him that yes, in fact, your injuries are severe, they are significant, they are permanent, they are disabling, and you suffered significant lost income as a result of these injuries. The defense offers $1 million with the expectation that this case would now be resolved, because that was the explicit consent that I received from you when we had our lengthy discussion about what the real value of your injuries are. Now, I call you up and I tell you, this is great news. The defense has finally offered $1 million to settle your case. Your case is now settled. And you turn around and you say, you know what? I changed my mind. I don't think my case is worth $1 million. I think it's worth 10 times that amount. $10 million. I'm not settling this case. You do whatever you have to, but I am not settling your case. Okay, now we've got a problem. We have two problems, or more. It depends on which viewpoint you take. The first problem is, based upon your original consent, that's how I was able to enter into settlement negotiations. If I had gone back to the defense attorney originally and told him I needed at least $10 to $15 million to settle your case, he would have told me, I'm sorry, we have no intention of paying that kind of money, so therefore we're not even going to begin negotiating, and that's the end of it. In which case you would have had no offer, and now we wouldn't be having this conversation. Number two, now we have a credibility problem. We have a problem because I made assurances to the defense that if they were able to come up with $1 million, or let's say $2 million, now we'd be able to settle the case. Now you're telling me that's not happening. So now I have to call the defense attorney and I have to tell him that we can no longer honor this settlement discussion and settlement agreement. And as a result, we can't settle the case. So what happens next? What happens next is that after I call the defense attorney to let him know that you, my client, has changed their mind and no longer is willing to accept $1 million to settle your case, you know what's going to happen? He's going to say, well, what do they really want? And if I say $10 million, he's going to have an immediate knee-jerk reaction, say that's never going to happen, and even if we go to trial, and even if a jury agrees that that's the true value of your injuries? He promises, based upon his discussions with his insurance company and his client, that they will appeal every step of the way, which means that after a verdict, if a jury gives you what you want, now they're going to ask the court to reduce or throw out your particular verdict. The defense will argue that the verdict is against the weight of the evidence, and there is a possibility that the judge will agree and throw out your case or certainly reduce it. Now, if we win at that stage, the defense will again go ahead and appeal to a higher court, to the appellate court, and then make a similar argument claiming that the verdict is way in excess of the extent of your injuries, and the verdict should be thrown out and maybe even set down for a new trial on damages. In which case, it will take you at least another 1 to 2 years to get a resolution, or at least to reach the point where you are back in front of a jury again and now trying this case all over again. And if you get a substantially large verdict, let's say for the amount that you're asking for $10 million, you know what will happen? The defense is going to go through the same exact process I've just described. They're going to tell the judge that this verdict represents an outrageous result and is inconsistent with the evidence and the testimony in your case. And he'll ask the court to go ahead and throw the verdict out or to substantially reduce the amount that you've been given. Then, regardless of the outcome, then they will go ahead and appeal the case, again to the appellate division, and now you're going to have to deal with an appeal. And on an appeal, anything can happen. The court could turn around and leave the verdict as it is. They could turn around and throw the verdict out, claiming it's against the weight of the evidence. They could turn around and reduce it. And in some limited instances, they could actually turn around and increase the amount that the jury gave you. Now, there's also another risk. Because the defense attorney and I have negotiated this case in good faith, there is the clear possibility that the moment he goes back and tells his insurance company and his client that you have now rejected a previously agreed upon settlement, there is the strong possibility that he will be instructed to revoke and withdraw that particular settlement offer, which means that $1 million will no longer be on the table. And it's unlikely that they will ever offer that again. So what are your options at that point? At that point, your only option is to try the case. So now your case will progress forward knowing that you had an offer of $1 million. You knew what was behind door number 1. It was guaranteed settlement. And now you're opting for what's behind door number 2, which is a total unknown. Did you know that when you go to trial, and now you are relying on 6 members of the jury, 6 members of the community whom you don't know, they know nothing about you until they get into the courtroom and start listening to the testimony and the evidence, there is the possibility that they turn you away without a dime. They may find that the doctor and the hospital staff who treated you were not careless. And if that occurs, you are out without a dime. They may find that the doctor was careless, but that his carelessness was not a cause of your injury. In that case, they never get to decide how much money you are to receive for all the harms and losses and damages you incurred, in which case you walk away with absolutely nothing. There is the possibility that if they find the doctor and or the hospital staff careless, and that carelessness, that negligence was a cause of your injury, now it is possible that they come back with a verdict that is significantly less than what you have previously been offered. Maybe they come back with $100,000. Maybe they come back with $500,000. And it is possible, and you're thinking, no, it's not. Yes, it is possible that the jury comes back with a number that is significantly less than what you have been offered. The jury is never told about these settlement discussions. The jury is never told about what we think the true value of your injuries are from a settlement standpoint, nor is the jury ever told how much the defense has offered during settlement discussions. So they are coming at this with a fresh set of eyes, and they may not have the same opinion that you do about the true value of your injuries. In which case, you've got a problem, because now you've given up a guaranteed settlement amount, which is what was behind door number 1, and now you're going and you're risking it all for what's behind door number 2, which is a total unknown. So why do I share this quick information with you? I share it with you to open your eyes, to help you understand how these types of cases work. Just because somebody put a bug in your ear and told you, no, your injuries are worth much more than $1 million. In fact, they're probably worth $10 or $20 million because of the following things, because somebody else with similar injuries got a bigger verdict and a bigger number or bigger settlement. Now, you have the perception that your injuries are worth so much more, and you are going to refuse any reasonable settlement offer, and now you put yourself, your case, and the amount of compensation you might be able to receive in jeopardy. You know, I recognize you're watching this video because you wanted to see the beautiful scenery here at the lake.
I'm just riding the bike.
No, I realize that's not why you're watching it, but you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.